sunlight.
Anyways, I'm looking forward to tonight's hockey game. I don't know about you guys. Still have hope.
Who is
The,
playing? I'm
the
totally
Oilers, the
lost.
Oilers in Florida are getting
Oh,
ready.
okay.
I'm looking forward to tonight.
Maybe
Obviously,
you
if you're not
shouldn't have asked
following,
the question.
Well, in Italy is the soccer playoffs, isn't it?
It is, yeah. But
Um,
I have no clue about that either, so I don't know.
don't blame
I
you.
just
Don't blame you. But it's exciting soccer in Italy and the Europe overall. It's always been
yeah.
exciting over there. Yeah.
I just know that Inter lost miserably. What was it? 5-0 against
That
Paris Saint-Germain at the UEFA. Yeah, that was pretty bad. But
Does Pedro follow, or you're the only one who has a little idea?
they
mm.
should have ice soccer.
That would be fun to watch. Not so much participate in. Okay, on that note, welcome everyone. Thank you so much for joining us today for Family Law Now After Hours. Today's topic is understanding legal jargon used by your divorce lawyer and clerks and whole legal team for that matter. We will cover the most common legal terms used in divorce cases to help you better understand your rights and options. Learn how to confidently communicate with your lawyer and interpret legal documents with ease. Please feel free to use the Q&A feature throughout the event on Zoom to submit your general comments and questions about the topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters, and any information or anything discussed today should not be construed as legal advice. And stay tuned until the end of the session today. We will be sharing how you can schedule a free consultation with our team, with one of our lawyers. So I'm joined by a beautiful panel today. So I'm excited to introduce everyone, starting off with Bill Rogers. Bill is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. Thank you for joining us, Bill. Next up, we have Golan Yaron. He is an associate family lawyer and certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements, as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. Thank you, Golan. Pleasure to have you.
You.
And last but not least, we have Pamela. Pamela Favotto is a family law clerk at Russell Alexander Collaborative Family Lawyers, bringing 8 years of dedicated experience in family law with a strong focus on litigation support, including trial preparation and assistance. Self-taught in the legal field, Pamela combines practical expertise with a background in social sciences to offer compassionate and effective support to clients navigating complex and emotional legal matters. Originally from Northern Italy, Pamela moved to Canada in 2012 and discovered her passion for family law in 2017. Known for her empathetic approach and attention to detail, she plays a key role in guiding clients through legal procedures and with clarity and care. A perfect person to have on the panel for today. And she's Thank now you. based in Padua, Italy, and she continues to contribute remotely to the firm. Outside of work, she enjoys cooking, reading, and traveling with her husband. Thank you so much to our panel, and thank you to our audience for joining us today. Without further ado, I will now pass it over to Bill Rogers to get started with today's topic.
Thanks, Daphne. The first topic is about a term. I guess it's kind of jargon. It's decision-making responsibility. Now, that actually makes sense. Decision-making responsibility. People can understand kind of what that is. But 4 years ago, before they changed it, it used to be called custody. And we always had to explain to our clients, custody actually means decision making. It's got nothing to do with where the kids live, where they spend their time. It's a decision making, and it's about significant decisions regarding healthcare, education, religion, and activities for the children. So I think it's better now that they renamed it, eh, Golan? When did they do that? Was it 2020?
I was just thinking you may have to update your band name.
Yes,
Full custody.
that's right. Soul, my
So
bad. Now
decision
they call it.
making.
Yeah, everyone used to want sole custody. No one knew what it was. Now it's easier. It's decision making, which again, that's what custody always was. And now they've renamed it so it actually matches. The name matches what it is.
Exactly.
And it's got nothing to do with where the kids live. Again, it's significant decisions, not day-to-day stuff. It's not that. Significant decisions about healthcare, education, religion, and activities. So it's less of a jargon now than it used to be. And Golan, I have a question for you. Theoretical question. Um, Again, it's decision making. It's not where the kids live. So theoretically, and I've never heard of this happening, but is it not theoretically possible for one parent to have sole decision-making responsibility and yet never see the children, have zero time? Like if you were a scientist in Antarctica or something and you had kids somewhere else and the other parent was insane, so they couldn't make good decisions, but they weren't in danger. You could actually phone in or email all your instructions, but you could never see the children. Is that theoretically possible?
I Theoretically, I don't see that that would not be possible.
Yeah.
Because the authority to make decision does not necessarily correlate to having the child with you
Exactly.
physically,
Yeah.
and especially in the set of circumstances you just described. I don't see why would that not be possible that if one is not able to make decision because he's a flake, and the other one is somewhere else with a more solid judgment and responsibility that can make these significant decisions. So
Yeah.
yeah, so theoretically, but
Theoretically possible. And
let's be practically that's
yeah,
not
I don't think it's ever been done, but and the way that I approach these things, Golan, I think you're sort of sympathetic to this as well. Um, is unless there's neglect or abuse, the best thing to do for the kids is have what they call joint or shared decision making because it
I
avoids painting one parent as a loser who's unfit to participate in decisions and the other parent is the winner. That's bad for kids. So unless there's neglect or abuse, to me, the goal should be joint decision making, which means you both have to agree and each parent has a veto.
That's
I
also the status
definitely.
quo, right? Oh, sorry, Gola.
Sorry, it happens that the development has been towards that a trend of joint decision making, and I would agree with you, especially in terms of the roles that we try to assign to each parent, and there's no reason really why parents should not be able to decide. I mean, if they were together and not living happily, they would still be making decisions together.
Yeah.
But nevertheless, there are circumstances that it's not possible. There are
Yeah.
circumstances that It's just the conflict is just too high, and if nothing's being decided, then there's no joint decision being made at all.
Yes, that is absolutely true. The legal test, as they call it, is you have to have effective communication between the parents, or you cannot have joint decision making. So there is that. But people fight about it a lot, and it's not a good fight to have if you can avoid it. And I know, Pamela, you mentioned something about status quo. What was that comment?
Yeah, isn't that joint decision making what the status quo is before any court order or before there is a court order that says otherwise? What parents have joined.
That's right. And before there's an order or an agreement, you're presumed to have joint shared decision making. So it's certainly a goal to do that. And sometimes it doesn't work, obviously, but um, it's very bad for kids to give one parent sole decision-making responsibility, or what they used to call sole custody. Because again, that portrays the other parent as a loser, and that's bad for kids. So, it's a challenging issue, but that's kind of the way I tend to approach it.
Right, and you're really stripping away parenthood from that parent, right? When you're
Yeah,
saying you cannot make any decisions regarding
yeah,
this matter or whatnot, but at least have a solid input that you are going to be considered in the decision. Now, if it's not reasonable, it's a different story. Sometimes we do have that situation of meaningful consultation and trying to show that there is some form of of input being put into the process. But at the end of the day, we want to see, and we spoke about efficiency and communication. We have to let people understand that we're not talking about a self-serving non-cooperation.
that's right.
Right. So one parent would say, "Oh, I cannot
Yeah,
communicate with the guy," or the other way
that's right.
around, just because they don't want to have a joint decision making. It's got to be a more on an objective test of the situation
Yeah,
and understanding, the dynamic between the parents. So
yeah.
yeah, that's definitely has been a major issue that's people are being spending their money on, unfortunately.
And
But
it's a very sensitive topic. I mean, Pamela, I know you've done a lot of litigation work, and the fights that go on. I mean, people spend a lot of money fighting over decision making, and it's very symbolically important to parents, even though the reality is there's usually not that many significant medicals, knock on wood, but usually not that many significant medical decisions. You listen to your doctor usually. So, education, unless you're in private school, it's not that many decisions. Religion, sometimes it's not an issue for people. So, but people will fight and they'll pay a ton of money, and so it's a sensitive issue. It's very different from parenting time, which is our next topic. They used to call it access, and they changed it. Now it's called parenting time, and it's totally separate from decision making. All it means is what's the schedule? Where does the kid live? And the kids, whatever the case may be. So and that can be an area for a lot of fighting as well, right?
because but we used to call custody and access issues. Now it's parenting time.
Yeah,
But people have to understand that the parenting time is just it's like you said, it's a schedule of when is the kids are with one parent or the other, basically being cared by one parent or the other, and it has a consequence when we touch the topics of support. But generally speaking, we're talking about really that technical parenting scheduling issues,
well,
right?
that's right. And you mentioned it does affect child support. And Pamela, I'm just wondering how many times you've been involved when people are fighting over parenting time because they want to pay less child support. Have you seen that a
No,
lot?
yeah. a lot of times.
Yeah.
Most of their requests to see the kids are not really to spend time with them, but because they know that there is an implication and they would have to pay less child
Yeah.
support, which is
Yep.
sad. But
Yeah. I
that's
mean,
the
one of my
reality.
colleagues said it's ruined family law because they never used to have that rule. And now they do. And if you have what they call shared parenting time, which is no one has less than 40%, then
Mhm.
you get a discount on your child support most of the time. So there's people who will, try to get more time just so they can save money, and who can blame them? But it's not the best rationale for going to court just because you want to save $1, but that's what happens.
I also, you know what? I think that they also don't calculate what it costs to have the child. So while they think that they may save $1 or two, they'd be spending 10.
That's
Good
so
point.
true. Yeah.
That's a really
They
good
Yeah,
point.
need,
but
yeah,
sometimes I've seen judges that say, let the person, put the money where his mouth is, kind of
Yeah.
thing, and see how long it's gonna last, or she gonna last with some obnoxious kids that have to
Well,
not
that's
give
right.
you
I mean,
not give you a rest for a moment.
there's a lot to be said for being what they used to call the Disney dad, where you've got the kids every second weekend and one overnight during the week. Um, you're basically the fun parent at that point, and if they'd give you the child support discount, even though you were just the Disney dad, I think more people would be fine with it. But I don't know. I don't know. I really don't. But anyway, so yeah, so that's again, it used to be called custody. Now it's called decision-making responsibility, which is a better term. So that's what it always was. And then access has now become parenting time. And those are super important issues. People go to trial on that. And again, my philosophy is if you can do it shared, shared decision making, shared parenting, the kids will thank you for it down the line because they're not going to have what they call the winner loser parent syndrome. But it's hard to explain that to a client who, you know, really has the hate on for their ex and wants to see a public execution. It's hard to share parenting with someone, so you have to try to calm things down. Our next topic, Golan, is for you. It's about support obligations, child support being based on actually child and spousal support are based on guidelines. Do you want to talk a little bit about that, Golan?
Right. Yeah. So we spoke about how the parenting kind of affect the child support issues. But when we talk about this topic of spousal support and child support, a and the formulas that are involved there, most people I think today know that the child support is based on there's a table that is being published. It's under the child support guidelines, and it's accessible to anybody if you go online
It's
and you
called the
just
Child Support Guidelines. You can see it online.
guidelines. But if you don't want to do a calculation, you just click on child support calculator, and you'll be able to find what your obligation is based on your income and based on the number of children you have. Um, the situation becomes more complex where the children may not be yours and you may be in a place of a parent, which is, we're talking about some terminology here. So, sometimes we use the term that a person was in a place of a parent and therefore we assume the obligation, and then you adding him to the equation of how many children one have for the purpose of child support. It can be more complex where you have children with different mothers, and then you have to apply the guidelines in two ways, three ways, or four ways, and it's not always the correct amount because I think the formula was based on a children in one family and not looking at it because that's why when you
Yep.
see if you see two children, three children, it's not going in a regular straightforward kind of incline. If you pay for one child 400, for two children it's 800, etc. It's not
Mm-hmm.
That's not the way it works,
No.
because the assumption is that in the household, there are some form of repetition or reusable resources that are available to the children. But what happens when the children are in separate households because you have different parents, and then what do you pay for two children when you have one here and one there? Now you have to pay for each one of them separately, and that could increase the financial hardship on the payor. The payor is the person that pays the support. But in any event, that's some complications, issues that are sometimes being litigated.
What about
The
spousal support, Golan?
Right. So
Which in America they call, I think they still call it alimony.
alimony, yeah.
Here they call it, and in England I think they still call it maintenance.
Oh, that's right. Yeah.
I think so. But
Why do you
here,
bring that up?
here we call it spousal support.
Right.
And
So the spousal support issue is normally the issue arises in a relationship of some duration and permanence, including commitment with children, some specific roles that one has taken in the relationship. And it's not necessarily married couples, it also applies to common law spouses.
Yeah.
And that's the reason that that topic of spouses of support issues are not related to legal married status. Unlike the issue of equalization, when I
Yeah.
think we mentioned that issue regarding division of assets.
And there's a misconception, Golan, that if you live with someone for 15 minutes, then they're eligible for spousal support. It's not 15 minutes. It's not even 1 year. It's 3 years. Unless you have a child with the
Right.
person and you're in a relationship of, quote, some permanence, unquote, which I don't understand how it can be some permanence. Like either it's permanent or not, but whatever. That's the law though.
If you have a
3 years
lover,
unless you have
if you have a second wife on the side, that would make it.
it's
but I'll tell you what the point is. It's not. It's maybe you mentioned it's a threshold. It doesn't mean that necessarily just by virtue of being a spouse you are eligible. We have tests here of entitlement. We have a test of the legal obligation to support. Sometimes we're looking at supporting at the level of need, meaning you just want to make sure that the other person is able to meet basic needs.
we don't want the ex to live in a trailer yet.
Or on the street in that respect.
Or on the street.
The other aspect is sometimes we're looking at when you hear about compensatory support, we're looking at different factors that has to do with roles taken during the marriage, advancement of one parent over the career of another, and then somebody's giving up their aspiration to the benefit of the family, the children,
Yeah.
and staying behind. And then by the time they separate, one is way ahead in terms of economic advantage or ability to support oneself, as opposed to a person that now need to be retrained or get some skills going, and all of that requires some consideration. So we have terms like a base need support, we have terms of compensatory support, we have terms of child support, we have also the terms of extracurricular support, which is the one that goes beyond the basic table amount that most people are aware of, which has to do with extracurricular expenses, activities, sports, recreational, and other things that are maybe beyond the basic needs of a child that are not covered by the table amount. So these
Sorry?
I'm saying
Sorry
these are the
to
major.
interrupt. Before we move on to the next topic, just wanted to pick up on you mentioned there's something called compensatory spousal support versus simple need based spousal support. And the thing about compensatory, just to clarify for our listeners and viewers, is um, if you have a compensatory entitlement, you get more and you get it for longer. And the way you get a compensatory entitlement is you make sacrifices for the sake of domestic considerations. That's how you get it. Typically, it means you do more of the childcare than the other person, which means your career was sacrificed more than theirs was. They were sort of freed up to go and make a bunch of money in advance, whereas you made the sacrifice. So that's one classic way you can become a compensatory entitlement, right, Golan?
Right, and that goes also to another maybe terms that we did not mention, and that is the duration.
Yeah.
So we're always talking about, when talking about spousal support, we're talking about two aspects there. The two tests of, firstly, entitlement, and the second one is, okay, so if one is entitled, then how much and for how long? And all of that has to be based on circumstances, but we have what we call the general advisory for spousal support that we use, but there is room for variations. There is room for taking a different stance,
Yeah.
even within the advisory guidelines. You mentioned the compensatory and how it affects. So again, there's another terms that sometimes being used in the context of spousal support, and that is a lump sum payment. Some people heard about lump sum, and some people heard about periodic support. These are concepts that we use from time to time when we discuss the issue of spousal support. The idea is that periodic is something that happens most frequently is a monthly basis. The lump sum is a consideration of a calculation, and this is the formula that's being used, basically trying to compute, okay, if I owe you this much support for the next 5 years, what would be the value of that amount today? And that becomes the lump sum payment that one can pay. There's obviously a tax consequences to either a option, but these are the terminology that we sometimes use in the context of spousal support.
And it's very much a fact-specific inquiry. Um, it's almost like you're rolling the dice if you go to court for spousal support. And Pamela, you're up for the next topic, which is about what we call bringing emotion. And I'm sure you've seen many emotions for many different things. You can bring emotion for parenting. You can bring emotion for spousal support, all that stuff. So, Pamela, do you want to talk a bit about what motions are and know what to expect when one is filed?
Yeah, absolutely. So we're gonna move away a little bit from a generic concepts and legal concepts and go more into the nitty-gritty of court procedure. Motion, an easy way to describe a motion is that it's a formal request that is made to the court, asking for a specific decision on a topic, on an issue. Essentially, you're asking the court to step up and to help you make a decision because you cannot find an agreement. And as you mentioned, Bill, it could be about a motion for child support. Your partner is not paying. Spousal support, you need some financial help and you can prove your entitlements. It could be about selling a jointly owned property. And what happens is that motions are very serious in the sense that they do require paperwork. They require people to submit sworn documents called affidavits. Very often you need to appear before a judge and you are asking the judge to make an order. Now, that order is going to be a temporary order, but I don't want our viewers to think that temporary is just a few months. No, temporary could last for years. So, or at least it could last until there is a trial. And I think, what is it, maybe 1% of family law cases reach a trial, Bill?
Yeah, that's
Or
right. Yep.
the percentage, okay, so very, very rare that you can get to trial. or a temporary order lasts until you're able to reach another agreement on a final basis. So the moment you're served with motion materials, which constitutes would be a notice of motion and an affidavit, it's super, super important that you don't ignore it, because it has very serious legal consequences for your family future and can affect you. Whatever decision that, if you decide to ignore it, the court may make a court order against you that is going to affect you and your family for years to come. So definitely something to be careful about. And that leads to the next topic, which, by the way, we got a question from one of our viewers here. And Golan, he or she is asking, can temporary orders become final orders if they pertain to decision making?
Well, so technically, a temporary order can become a final order when a final order is made. So if there is, like you said, a decision that was made and there is a court order at the moment regarding a decision making, that's what stands until there is a different order.
And it can go for years, like
It can
Pamela
go
said.
right
People run out of money and they can't keep going, so they'll have a
well,
temporary order that's 5 years
the
old.
that's the existing order. So
Yeah.
that's what we go by.
And there's nothing wrong with it.
Nothing's wrong with that. And then, well, people have to pay attention. If that's what they wanted, they would end up with either a separation agreement or they'll file something to finalize to have a final order on the matter.
Yeah.
So it actually just to kind of add more to the concept of emotion that Pamela started talking about. There are motions that have to do with substance. There are motions that have to do with procedure. There is the procedural issues of, one is being served with a motion, which is, like Pamela indicated, the formal request that has a legal consequences. It could be done normally. You have to think of it as the step under the umbrella of the main event. So if the main event is that somebody started an application and there is an answer, within that proceeding, you have a little steps that leads you from point A until the trial, and you need some decisions to be made to allow these people to continue until they get to that trial, or they finalize their matter in a settlement of some sort. So the motion could be procedural in terms of timing, filing concepts, paperwork, affidavits, and disclosure that may be relevant to the issue, and this could be done over the counter, as we call it. When we say over the counter, we mean that nobody is appearing. The written material goes before a judge. It has a pile of what we call basket motions that's sitting literally in his basket and just waiting for him or her to go through it and give a decision, and then the decision is being delivered to the parties. The other type of motions that Pamela was referring to are the ones that are, over substance, and these could be sometimes done virtually, or sometimes they're being done required you to appear in person. These are based on written material and not what we refer to as oral evidence. So unlike a trial, the judge is looking at your sworn evidence that both parties have provided, and the submissions of their counsel and any legal arguments that may be relevant to the topic. So that's kind of the concept of how emotion is what emotion is based on. And then you have a decision that a judge renders sometimes immediately, sometimes they reserve their decision to a later date. And then that decision is what stands until there is a different order or agreement that the parties may come up with. So that's
Right,
kind of that also answers the issue of that topic of final order replacing temporary order, temporary agreements. But definitely it trumps final order is a final order, exactly how it what the terminology sounds like. That's what it
And
is.
that's
Totally.
I wanted to ask Pamela about it, the affidavit, because when you're doing a motion, um, it's not like a trial where you can actually testify. Um, your evidence, all the things you want to say to the judge, you write down in an affidavit. It's like you're telling your story, and then you swear. It's like under oath. And what Pamela will do is look you in the face or over Zoom and say, "Do you swear it's true?" And they
That's
will say
correct.
yes. And if you lie in an affidavit, it's perjury. So it's serious stuff.
It
And
is.
Pamela, I wanted to ask you, like I'm sure you've done many affidavits for clients when they're telling you their story. And can you just talk a little bit about what that process is like?
Yeah, absolutely. So an affidavit, like, of course, it depends on the issue of the motion that you want to bring, but you want to give a brief background. So usually state the your relationship dates, the children, the arrangements that have been in place. And then it depends. Like if it's a child support motion, then you're going to want to list the efforts that you have made to seek child support from the other side. You're gonna want to mention how many times the other side has paid support. You will want to put something in there about the fact that you're struggling financially, that you cannot continue this way, that is being really prejudicial to the children and is harming them. So, but again, this is about child support. Then
And what about a
emotion can be,
what about a parenting motion? That's where you get the mudslinging.
yes,
Can you talk a
yes.
little bit about about that?
Well, when it comes to parenting, you want to describe your role as a parent during the marriage or the relationship. So, what is it that you were doing? And the more in detail you go, the more realistic and true the statement is. Like, and I'm giving an example, like, I will take care of bed routines, of changing diapers on the weekends. I would enjoy to go to the park or to go to Wonderland, or like just don't be afraid of really giving details about the things that you would do for your children and with your children. And also the fact that the children enjoy spending time with you. When it comes to attaching exhibits and like the so-called evidence to your affidavit, that's a whole other universe, but you want to
Here's
be as
5,000 evil text messages from your ex. It's like, no, pick the top three, or I should say the bottom three, the worst three, not 5,000, because the
That's
judge don't
right.
want to
Also,
read through 5,000 texts.
they don't want to read it, and your materials are
They
simply not going
won't
to get
read. Yeah.
accepted. They want to get accepted because since after COVID, that are strict page limits when it comes to affidavits. So you cannot, I believe you have, in most jurisdiction, you only have 10 pages. So all of your text messages, I'm gonna have to combine them in one page, and
Yeah.
you're gonna have to pick and choose what truly is relevant
Do you get a
to the
lot of
motion
people
you're
who are,
bringing.
do you get a lot of people, Pamela, who like start crying when they talk to you?
Mm-hmm.
Yeah.
Yeah,
It's a
yeah.
it's a tough business, family law, isn't it?
It really
Why are we
is.
even here? Why are we doing this?
Yeah.
Let's get
And
jobs somewhere else. This is
it's
ridiculous.
it's specifically because of the emotion and the all the feelings that get
Yeah.
involved that makes this field so difficult. Um,
And the thing about
uh,
family law too that is different from regular civil litigation is that family law has these things called conferences, right?
mhm.
Um, and those are kind of the prelude to a motion. You can't do a motion normally until you do what they call a conference first, where you sit in front of a judge and they try to uh, give their opinion. The judge will give their opinion on your situation and try to get you to come to some kind of agreement because they really don't want you to go to a motion because it's really expensive and it takes court time and it's not good. So the beauty of family law to me is the conferences. And you're better off if you can avoid going to a motion, avoid it. What you want to do is you go to the conference and you listen to the judge very carefully, and then you try to come to an agreement.
Compromise.
Because at a motion, the judge does make an order, regardless. Like obviously, you're not agreeing to it because you're at a motion, so they will make an order. At a conference, a judge cannot make an order unless you agree, and it's on consent. And the more I do this, the more I appreciate those conferences, right, Golan? Like you go, and the judge basically tells you what time it is. Here's the situation. Here's what I think is going to happen, and it's really, if you can do it and just listen to what they say and try to get some kind of agreement, even temporary, that's a huge, huge benefit.
But that's the importance of using conference properly
Yeah.
and having because you can really utilize it in that way to achieve that result that you just mentioned.
Yeah.
Others may just think of it as a step to move to the motion, which is a waste of time and money. I think if you recall, Bill, you were you have the seniority in that sense that before the conferences, the first thing that people used to do is emotion. There was emotion for spousal support, motion for parenting, custody, all of these things were the first thing that came to
Yep.
court, and it was so inflammatory and adversarial that the rule committee were trying to really diffuse that tension and just say, listen, let's just give these people the opinion of a judicial opinion, so maybe they can go according, if they clue in, if they're smart enough, they clue in and they will realize that's going to be the end result here. Maybe I should just go with that. And in my reasonable or unreasonable position has to be relaxed to align with that idea. So you got to be using the conferences wisely. That's the reason you want to have, if you're able to speak for yourself, excellent. Otherwise, you may want counsel to assist you with the presentation and the written material. It's also important that the written material would be, succinct. The point is, you mentioned all this mudslinging, and that's not necessarily what I find is judges do not appreciate this, this mudslinging.
Yeah, judges do not. They do not like mudslinging, and everybody
Absolutely.
wants to do it, and they don't like it.
Right.
No.
It reflects badly, I think, on a person that just speaks badly on the other parent. How would you be able to tell your kids differently if that's what you're saying on the other parent?
Exactly.
So there is an issue there. I think there is a logic around it and common sense that they try to kind of take the flames down and just look at the essence and merits of things. Sometimes there are bad things that happen, and you need to mention them, but there is sometimes just a lot of noise that doesn't take you anywhere, and you need to isolate those and be more focused. And Pamela mentioned all these restrictions on pages is not for no reason. It's just that put your best foot forward and
Yes.
and concentrate on the main thing, and that's how
Yep.
we struggle sometimes, and the editing sometimes takes you more than the time that it takes you to just write the affidavit, right?
Well,
Because
that's right. And I'll tell you this, Golan. I mean, most of my clients, I don't know about yours, they want to be vindicated. They want someone to say they're right and your ex is wrong. A lot of people want that, and I don't blame them, and it's natural. But judges don't want to do that. Judges don't want to assign blame for the past. They want to point to a way forward for a better future. That's what they want to do. So, and it's sad because everyone wants someone to say, you know what, you're right and she's wrong, and it's natural, but it's not what the judges want.
Right, and don't forget this. It ties up to another concept that did not mention in the parenting issues, which is the best interest. We always say that, it ties up to that issue of where is the parenting, or how is the parenting should be framed, and because it's all goes back to what's best for the children.
Yeah.
We're not looking at the parents' best interest. We're not looking at why he doesn't like this parent or that parent. The idea is it working for the children? Is it working for the child?
You don't want most people, I mean, there are terrible cases, obviously, but for the most part, I've told this to my clients, it doesn't usually go over well, but maybe there's a better way of saying it, but we don't want your kid to think about your ex the way you do. Okay? They probably, in most cases, love your ex, and that's a good thing. You know what I'm saying?
Yeah.
Yeah. And it's super hard because
100%.
you know what? There's a lot of hard feelings. Divorce and separation is one of the most devastating things you can go through. And it's super hard to open your mind up to that kind of thinking, but and it takes time, but that's the way the courts nowadays are designed. And that's the approach they do take, and shall we move on to the next topic?
Shall we? Of course, it's
Would
already.
you like to? Did you have something super important you were about to say, Golan?
No, I'm happy to
Okay.
contribute on the next topic,
Okay.
please.
Pamela, this is for you. Disclosure, which means like showing your bank accounts and whatever to the other side. People don't want to do it. Can you talk a bit about what disclosure is like and how you're supposed to be honest and stuff, all that kind of stuff, Pamela?
Yeah,
You look like you're frozen. Oh my God.
Maybe
Either she's lost in thought or it's frozen.
I'm frozen. I'm
Oh
sorry.
no. Okay.
Sorry
but
about
we
that.
hear you.
We can hear you though. And it's frozen on a flattering picture of you. So just go with it.
I tell you what,
we can't hear. Okay. So I'll
take over for now, and she can join us.
You're supposed to disclose stuff, even though you don't want to. And yes, it's a pain to get your bank accounts, God knows your statements of your investments, all that stuff. It's a pain. My approach, Golan, I don't know if you do this. If an opposing lawyer asks me for something, my answer is always, unless it's something really weird, it's always yeah. Because you know what? My client has nothing to hide. And if you say, no, I don't want to show you that stuff because I can't be bothered to get it, then all of a sudden, it looks like you do have something to hide.
It's true in most cases, but sometimes you have to have a little bit of a balance. And what I mean by that is that there's got to be, you're not looking to satisfy a fishing expedition. You're not looking to spend a lot of money on statements from 10 years ago.
Right.
This would not be proportional. And that's what you're looking for. You're looking
That's
for
true, yes.
proportionality,
Absolutely.
and you're looking for balance. Now, the main thing that people have to understand is there is not only an obligation, it's a legal obligation that the court is expecting you to disclose even before any motion or any of the before you even being requested to do so. Just by virtue of, it's almost like saying do it before we tell you to do it.
Yep.
And there is some basic disclosure that we're talking about when it comes to income and it comes to assets disclosure. When we do that normally in a financial statement, and it's a sworn document, guys. Don't forget that, right? You're swearing that this is all you got, and you swear to your debts and to your assets on specific dates, whether it's a separation date or the marriage date. And all of the assets and the supporting documents that would that shows the value for these assets and debts would be there. Now,
there she is.
Are you with us, Pamela? No, she's still connecting.
Oh.
I'm so sorry.
No worries.
Don't be.
Technical issues. Sorry, everybody. I was so excited about this topic. Where did you guys get to?
Well, we haven't really, all we basically said was if someone asks you for disclosure, you should give it unless it's out of proportion. I mean, if they want your bank accounts from like 1974, that's going too far. But you don't want to be the person who looks like they have something to hide. Does that make sense to you, Pamela?
100%. And trust me, that happens all the time. It's either they're trying to hide assets or there is an income stream that they don't really want to talk about. And every time I talk to clients, this is what I tell them. You're in court, you gotta be an open book.
Yes.
Lay all of your cards on the table. Full transparency, full honesty is essential. It's appreciated. When you try to hide assets, that's when things start to go south. And why? Because you can get penalized.
Yeah.
Penalized by the court in terms of having to pay the other side legal fees, or even having an imputation of income, which is when you refuse to provide disclosure regarding your income, and the court is just going to say, you know what? Based on this evidence, this is going to be the income that we're going to assign to you, and you're going to have to pay child and spousal support based on that. So that's not something that you want. You want, and it's hard. I mean, it is a lot of paperwork, and it's normal for some people to feel nervous about it because sometimes, they never, like, they had a bad separation or they never had joint finances, so they don't really want to know the other side, what they were making or what their assets are. But in family law, it's you're legally required to produce financial disclosure. It's not an option.
And I think you
And
hit the nail on the head, Pamela. You have to be an open book.
mm-hmm,
And as
yeah.
Justice Perkins, who's now retired of the Superior Court in Toronto, once famously said, if you lie about anything, money or whatever, the judge will eventually find out. And when they do, it's not pretty.
No,
Because
it's
then they don't
not.
ever believe anything else you say. Right? That's the problem.
Mhm.
Next topic, got a little bit of time left. We're going to try to wrap this up around 6. So the next topic here is minutes of settlement are binding agreements. Now, minutes of settlement, why do they call them minutes? I don't know. But minutes of settlement are what you and the other side take a piece of paper and a pen and write out a deal that you're agreeing to in the hallway outside the courtroom. That's usually the way that works. And it can happen in other ways too, but that's very often what occurs. And then you take it into the judge, who typically has said to you, why don't you guys go out in the hallway and cut a deal? So you do, and you come back, you show the minutes of settlement to the judge, and it is incorporated into a court order. So yes, it's binding. The interesting thing is when the judge looks at it and says, I can't make this into a court order. It's unlawful what you guys have agreed to. For example, this is an example. I don't think anyone would do this today, but maybe if you agreed that one of the people could not have a boyfriend or a girlfriend, like for the next 2 years or something, a chastity clause, as they used to call it. I don't think you can do that anymore. So if you were dumb enough to like write that out with someone and then give it to the judge, what would the judge say to that? Go on.
I don't think they would be appreciating
No.
the paper that it's written on.
Right. But if there's
It's
other stuff in there that's okay, and then there's just one or two things that are bad, the judge will typically say, well, you got to cross that off. You got to cross that off, but the rest of it's okay. Right? Have you ever run into that?
right. So the point is when and where the minutes is being concluded, right? Because minutes of settlement could be done between lawyers in their offices, exchanging signatures electronically or not. It's a binding agreement, just like any contract. So minutes of settlement, other words, is a contract. I think the words minutes comes as a words to say a summary of the settlement. Just kind of when we used to do like what are the topics, and then we go into the details of it in a comprehensive agreement that takes over the minutes plus many other details.
Yeah.
But the minutes itself, if it's clear enough, it's a contract like any other contract.
And you do have to normally sign them, right?
And absolutely need to be signed. Now, if in the context of family, in order to make it a domestic contract, you also want to make sure that you have the other formalities in play, including lawyers involved, independent legal advice, opportunity, and the other formalities that goes with it. And like you said, if you're doing it in the hallway and you just bring it back into the court and say, "Hey, Mr. Your Honor, we'd like you to turn this into a court order," then it takes a look at it and try to kind of readjust it into a format. So we're just talking about changing the format into a court order as opposed to keeping it the way it is as an agreement. But either way, whether it was not in court or whether it was just done between the lawyers, it would be a binding agreement.
Now, the next topic, Golan, is arbitration and mediation. And they are really handy tools. And here's a question for you, Golan. Mediation usually, after you mediate for, could be a day, it could be several days, whatever, and then you come up with sort of an agreement. And a lot of times, they don't all do this, but a lot of times the mediator will call it a memorandum of understanding.
Right.
And you do not sign it. Correct?
Because it's not an agreement. It's just it's a summary of the topics.
They want to give you a chance to sleep on it. Now, some mediators will make you sign it there on the spot because they know what's going to happen. Okay, you're going to change your mind.
The buyer's
remorse.
Right.
So what do you do?
I am in favor of concluding a deal. If you have your lawyer with you, you had the opportunity to consider it. You don't need to sleep on it. You got the recommendations. It's not going to get any better. It is what it is. You consider it. You have your time. If you need more time, that's a different story. But again, it depends on the circumstances. But most situations I've been to, in order to make that mediation worth your while, there's got to be a conclusion. Otherwise, you just wasted the whole day or a lot of money. The topics though, and that we're using mediation because it's an opportunity to get out of the court world and really be a master of your own destiny.
Yes.
You wanna be able to control what is it that you're going to agree to and what the final result's gonna be. You better do it in a mediation and compromise because you don't know what you're gonna get. And that's really the trade-off. You either you go to trial and then you take your chances, or you control your result by going to mediation and make it work so you at least know that you can live with it because you agree to it. The most likely is that you're actually going to follow it. That's from my experience.
100%.
The other issue we're speaking about kind of ways to avoid a trial. Arbitration is not really avoidance of a trial. It's really just kind of taking it into a private scenario.
So you don't have to wait like 3 years.
Right. You don't have to wait, but you have to pay. Yeah, you have to pay probably just as much.
It's like a private trial that costs a ton of money, but you don't have to wait 3 years.
Right, and you get your privacy in a sense.
Yeah, no publicity. That's absolutely
publicity there. So there's a lot of there are advantages to that, but we normally talk about mediation. Collaborative sometimes is another process that we can use to kind of let the people decide for themselves.
Absolutely.
We can help you do that. We can guide you through the legal terminology, exactly all the terms that we just spoke about here. And all of that comes into play. And once you know the legal expectations, you may be able to agree. When you go without that into court, and you're just saying, "Look, I think that I should get the kid full time and have decision making, and not pay anything," and you go with that kind of a mind frame, and then you're just going to be disappointed. But if you go and speak to to counsel and you go to mediation and you get all the right principles to apply, you may be able to come to terms with what's right and what's reasonable.
Well, I think that's absolutely true. And you are a mediator.
I am. I do that too. And I love doing that because it's really satisfying to see people, helping people arrive at an agreement.
And it's
Because
much better. Like nobody likes a trial, except for
it's
the
not
lawyer. The lawyers like
it's
it.
not always going your way in the sense that
Ah,
you lose some, you win some, but it's never exactly what you
yeah.
expected.
Mediate. If you can stomach mediation, it's better.
Oh yeah.
And the courts, by the way, have low-priced mediators that you can go to. It's geared to income. So even if
Yeah.
you're in court, you can still mediate, and it's never too late to settle.
And that's the reason that they conference you to death, right? They
Yeah,
want you
that's right.
they want you to
Okay, so we're
listen.
just going to wrap up with Pamela. Always, always ask for clarification if you don't understand, which pretty much most people don't understand really any of it, and I don't blame them. It's super hard. Um,
It is. It
no, yeah,
is.
of course they understand some of it, but it's a learning curve. And talk to me a little bit about that to wrap up, Pamela, please.
Yeah, no, I mean we've talked about so many legal jargons as Golan was saying during this session, and it can be overwhelming. It's overwhelming because it's so emotionally charged, and you're going through a separation, and your kids are involved, and it's easy to make mistakes and to take the wrong decisions. But that's what the lawyer is there for.
Yeah,
And it's not just to represent you at court or to recommend mediation, but to actually explain in simple words in a way that makes sense certain terminology or procedures or anything that comes to mind through this. So that's why your lawyer is there. Asking is never a weakness. It's always a strength, and especially when this decision can really affect your life for years to come.
absolutely. Don't be
So if
afraid to ask, and there's no such thing as a stupid question. Except for
never,
that one time when I asked that really stupid question, remember going, but that was like the only stupid question that's really ever been asked. It was by me. Most people's questions are not stupid. Don't be afraid. That's what we're here for. And on that note, to wrap up this presentation, first of all, thank you to all the viewers and listeners for attending. Um, and if you have questions, you can get a free consultation with Russell Alexander. What you want to do, I think there's a survey that you're going to get after this, and there's some mechanism there to request a consultation, or you can contact our firm, and it's easy to find the Russell Alexander website, and contact us and mention after hours, which is what this show is called. Mention after hours, and they will set you up with a free consultation. And there are no dumb questions.
that's right.
Thank you, Bill.
So thank you,
Thank you,
Golan and
Pamela.
Pamela.
Thank
Really
you.
appreciate um,
The after hours.
the after hours, and to all the viewers, thank you. And remember, there's light at the end of the tunnel, and we're here to help you.
Go
That's
Oilers.
right.
That's right. All right,
That's right.
I'm gonna shut this down now. Bye, everybody.
Take
Have a
care,
good
guys.
night,
Bye.
everybody. Bye.